Шановні журналісти, ми продовжуємо роботу. І зараз будемо говорити на тему люстрація суддів, заснування громадського руху «Справедливий суд», діяльність Вищої кваліфікаційної комісії суддів України та Вищої ради юстиції. Нашими спікерами будуть Дмитро Мартсон, лідер Народного комітету реформ та люстрації, Олег Гірман, член Харківської громадської люстраційної палати, та Oleksandr Cherkov, член Харківської громадської люстраційної палати. Шановні експерти, прошу до слова.
Добрый день, всех рад сегодня приветствовать. Для начала хотелось бы сказать, зовут меня Дмитрий Мартсон, поблагодарить данную площадку, медиацентр за возможность высказать нам свое мнение и, чтобы никого не задерживать, перейдем к непосредственно теме нашего брифинга. На наш взгляд, тема люстрации судей, тема очищения власти на сегодняшний день является одной из самых важных в нашем государстве. Мы видим частые прецеденты, когда из-за действий суда даже хорошие, благие, нормальные инициативы в государстве умирают, отходят на задний план, превращаются в извращенное, в искаженное какое-то действие, которое не дает того толка, которого бы мы многие хотели. Значит, мы до сегодняшнего дня уже проводили ряд действий, направленных на конкретное очищение судебной системы. Какой сегмент первый мы взяли и хотим сегодня с ним поделиться? Была пресс-конференция, мы о нем говорили, сейчас продолжим. Мы говорили о назначении тех судей, которые 5 лет отработали, хотят назначиться бессрочно на свою должность. К данным судьям мы, так сказать, применяли анализ и проверяли их работу, их деятельность, их финансовое состояние. И нам удалось, в принципе, первый раз за историю Украины, нам удалось остановить назначение всех этих судей таким пакетом, вагоном, как это раньше всегда происходило. И действительно, чтобы депутаты и общественники начали их анализировать. И после этого, в том числе самых одиозных, которые туда попали, которые запрещали мирные акции, которые во многом довели до того ужаса, который в нашей стране произошел, нам удалось их оттуда уже убрать. Мы хотим то есть есть конкретные фамилии, конкретных людей, которых удалось убрать из судейского корпуса, которые запрещали, в основном это мирные акции. Теперь мы хотим продолжить эту практику и хотим поделиться информацией, за запросом которой мы обращаемся к обществу. Значит, вкратце пройдемся по блокам. То есть для того, чтобы не создавать кашу, мы выработали алгоритм, какой необходимо предоставить для того, чтобы конкретный судья, рвущийся на бессрочную должность, был остановлен. То есть первый блок – это запрет мирных акций, привлечение к любой форме юридической ответственности. Если судья так или иначе запрещал мирные акции, митинги, привлекал к ответственности евромайдановцев, автомайдановцев, забирал права, любые другие действия, это является одним из критериев, который очень важен, и он достаточно конкретный. То есть можно предоставить решение суда, и этого будет более чем достаточно, либо постановление. Если это административная ответственность, это четкий конкретный прецедент. Далее, Европейский суд по правам человека. Мы знаем, что Европейский суд по правам человека выносит решение против Украины, но если в основу данного вынесенного решения легло решение данного судьи, и, соответственно, оно было признано неправосудным и неправомерным таким образом, безусловно, косвенно, потому что Европейский суд не имеет права отменять решения наших национальных судов, то это тоже одно из оснований для подтверждение недостаточной квалификации этого судьи. Очень важный критерий несоответствие расходов, доходов судей, которые точно так же желают назначиться. То есть мы считаем, что это очень, так сказать, важный критерий, когда люди видят, в каких замках часто живут наши судьи, на каких машинах они ездят, и при этом их официальные декларации действительно доступны. И в контексте предыдущей конференции об открытости, к сожалению, она не сразу заработает, система открытости, но когда она заработает, это дополнительно приобретет вес. Но и даже сейчас те люди, которые имеют факты, мы просим их предоставлять действительно для того, чтобы то же самое говорить об недопущении таких людей, которые явно укрывают свое имущество, к должности в работе судьей. Ну и это решение ВКК, то есть Высшей квалификационной комиссии судей Украины и Высшего совета юстиции по этим судьям, то есть если есть такие прецеденты. Плавно переходя, так как у нас одна из тем, это в том числе анализ ВКК, хотелось бы поделиться. То есть мы проводили ряд информационных запросов, ряд приемов. То есть вот за моменты действия 2010 год, 2014 год Высшей квалификационной комиссией судей, вы можете проанализировать этот факт. А те судьи, которые работали, вот они как раз сейчас планируют назначаться бессрочно, за 5 лет в среднем от 3 до 5 открытых дисциплинарных производств Высшей квалификационной комиссией судей. От 3 до 5 за 5 лет. То есть фактически у нас идеальная судебная система, на которую никто не жалуется и так далее. Более того, практически на каждого судью есть до сих пор открытые дисциплинарные производства. То есть на тех судей, которые подаются в парламент уже на утверждение, есть до сих пор не рассмотренные дисциплинарные производства о их привлечении к различным видам ответственности. То есть мы считаем это недопустимо, мы будем эту информацию выявлять, мы будем с ней работать, просим к ней максимально приобщаться. Мы довольно долго, и ряд общественных активистов...
Quite a long time we were trying to create the higher Council of Justice, the highest qualification commission, and we managed to do that. We are happy that finally the work has started. The civil servants declare their readiness and desire to clean up the judicial system. We understand that without participation of the public, of people, if we just rely on civil servants, nothing will happen. We were forming our Committee on Reforms and Lustration. We are founders of this movement, Fair Court, and we believe it should provide to people the very specific algorithm of work of fighting for cleaning judiciary. Here at the level of Kyiv, we understand it. We have developed we have drafted the statement on disciplinary violation. We have email, there will be a page in the Facebook, there will be internet site, the hotlines. It will all be in Facebook, and you will be able to give us information this way. Then this information will be put into a legal algorithm and will be sent to either High Council of Justice or High Qualification Commission of Judges, because very often the complaints are submitted and for years they are sitting in the commission. Now we're trying to accumulate maximum efforts of the public around this process. Many MPs want to help in that. We're happy because of that. Besides that, we applied to international institutions. We negotiated with some of the embassies. The US Embassy expresses their readiness to support all the directions of reform of judiciary, and other countries. International anti-corruption organizations understand that without reforming the court, fighting with corruption will never start, because we see some cases which then die. They are also ready to support, and now we need just to introduce it at our level in our Ukrainian cities. We are now talking about Kyiv and Kharkiv, where we launched it. We are planning to have a dialogue with Odessa, then Dnipropetrovsk, the cameras, transparency, publicity, legally correct algorithm. We introduce it and we start our activities. That is briefly what I wanted to share. Oleg, also activist, will express his position.
Oleg Girman, Kharkiv Lustration Chamber. As Dmytro has said, our main task is purification of the court branch of power, or the judicial. This is the foundation, and what's been done as of today, dozens and hundreds of people are united and assembled into a certain structure that collects information, what we can do together with the state, the civil society, and the state. Today, the High Council of Justice was changed, and the Qualification Commission as well. So there is a certain step forward on the part of the state. The second stage is the civil society. We are the link between the state and society. We will raise all this information and bring to the High Council of Justice and other controlling bodies, and this will provide a specific, concrete example. People are tired of seeing all these revelations about judges who take bribes, and then it all becomes quiet, and we understand that this is a road to nowhere. We have to say stop. People are tired, and only in this way we will be able to bring about specific changes. So this is the position. Oleksandr Cherkov, I am the coordinator of the Kharkiv Lustration Chamber. As far as the judicial is concerned, as of today, the people, well, there's no trust into judiciary on the part of people. Those who had to deal with the judiciary understand that practically all judges are protracting with the cases, or they rule in the interests of those who are interested in this. Our task as civil public activists is to control those judges and to unite all the people, and our task is that these judges, when we conduct lustration, will be ousted, and only those judges who are decent remain. And we want people to begin to believe and trust in the judges. Of course, there's a lot of opposition, but we will assume responsibility and we will cope with this. Thank you, colleagues. Are there any questions? And please introduce yourself. Dmytro Martson, protection of common people. Yes, you're right in saying that we all are tired and we all want what you declare, but I have a question. Whether you know, well, you said that we have to reform the judiciary. Purify. Then my next question is whether you know that over the 23 years of our independence, the judiciary was not created. Maybe you didn't know, but we are going along, we're going across the country and we are closing courts because we have found out that all the courts have acquired authority. You know, the country has declared independence, and all the countries lost their legitimacy, and we had to create new courts in order to legalize themselves. All the courts on the territory of Ukraine were registered as subjects of entrepreneurship, as economic objects. Do you know what this means? They are actually shareholding companies. So why should we lustrate private entrepreneurs? You know, they should not be illustrated. We just have to set the courts anew. In order to lustrate the judges, you have to spend $5 million. Why should we do this? We just have to create the courts anew. We went to a court today in Shevchenkivsky district of Kiev, and I tell the judges, dear judges, here is my certificate and here are my documents, but you are who you are. You are sporting a mantle, but tell us who you are. Where's your certificate? Where's your oath? You have this, to have this in the materials of the case. Okay. Thank you, Dmytro. First of all, thank you for coming here. I know your activity, I read about it, it is very interesting, and I think that if you develop this direction, we will support it. But today we have other realities that we have to fight. Of course, we want everyone who works in this corrupt system be dismissed. But we see that the parliament is appointing those people who have been working during Yanukovych's time. Not even they do not dismiss those who were compromised, but they are appointing them anew. We see all this, we understand, and our task is very simple: to implement the instruments that can be used. We see, if you are talking about fully disbanding the courts, this is one of the options, but we chose this option, which I think will be very useful for making the system healthier and fighting against them. But do you know that as of today, according to the procedure of the creation of a judge, only 170 judges have come through a legal, lawful procedure and have the authority to sit in court. I know this from reliable sources, from an MP. 170 judges, and the rest, 8,500, are unlawful. They don't have the right to wear a mantle. Whom shall we lustrate? We heard your idea, your radical concept. If you can prove it and get a chance to realize it, would be very cool, but so far I don't see a chance to implement this. But what we are talking about, I understand as specific steps that can work even tomorrow. And the law that MPs have voted yesterday for about property registers gives us even more possibility to control judges. If your option does not work, then I think that we should really work along our lines. I would like also to add, you see for yourself very well when they prepare lists of justice to the parliament who want to sit in the court for the rest of their lives, you see how this is done. So at this moment, what you are doing, as Dmytro said, is very important. And let's combine our efforts, because our main task is to work for a result. Let's join our forces. Dear colleagues, we have another question. Sergei Kutnyakov, Moninform Agency. Yes. There are different forms to make Ukrainian court work in a just way, but I still have a question to Dmytro, as one of the leaders of your team. There was Maidan, there was a public assembly, Vicha, and there's an understanding or a notion of a public assembly right when the public gathers and they solve essential issues of even state level. And this tradition hails from Kiev Rus, when they appointed or invited a prince, or when they declared war or peace, or when they punished those guilty. What about this form of just court and the People's Assembly? What would you say? Well, my personal position, and my colleagues may comment, understand what I want to say. I am a lawyer myself, and why we suggest this concept. I understand now that the main thing for us is to achieve a result within the current system and to deliver painful and specific blows at the system. The most unpleasant thing for them is to build this judicial algorithm. Of course, very good to say that we will disband all the courts because they are illegal. And yes, you are talking about public assembly. We have a public assembly in Kharkiv. People do discuss things there. But if you want to give People's Assembly some legal rights, then probably we should develop a draft law. And of course, this will take more than one day. But if this is a public control, then this is cool. This is all within the algorithm of analysis. There's People's Assembly, then Dmytro comes and you come, and they analyze everything, where they, for instance, whether justice just break the law, where they keep people in jail in bad conditions. Yes, of course, this is a form of democracy, and we should develop it, but how will you build this into the system? Dear colleagues, journalists, maybe microphone. I can't hear the person. He doesn't speak to the microphone.
Do you have any questions, clarifications? If not, then one from UCMC, Dmytro. You mentioned that now some of the judges were not allowed to continue hold their position. How many of them were not allowed? How many in Kiev, how many in Kharkiv? The first stage of lustration was selected by us in Kharkiv region. In Kharkiv region, we managed to stop all the judges of administrative court. That's about 7. They appoint up to 30 from the region. In percentage, that's quite a lot. A few people from district courts, but the main one is administrative. Why administrative? Because it prohibited all the peaceful actions, and all of them were about prohibition of peaceful actions in Kharkiv. And they were submitted to Verkhovna Rada, and they had to be approved, and that's a shock when we stopped it all, and the individuals started considering that individual, and then the committee removed them. So now a specific result. If we take it further on, it will be excellent. I would like to thank you for your presentation.